By way of introduction, my name is Beeston and I am a property litigation solicitor here at VWV based in London. And today I will be discussing the Commercial Rent Coronavirus Act 2022, which received royal assent on the 24th of March of this year, and the implications that that act has for the recovery of rent arrears. The Act introduced a binding arbitration process on landlords and tenants and replaces the previous legislation which imposed various moratoriums on certain landlord rent recovery remedies. So today I will be dealing with the aims of the Act, how it works in practice, the implications for rent recovery, and a few criticisms of the Act as it was obviously rushed through Parliament at sort of record speed, and there are quite a few concerns to do with how it works in practice. So the Act refers to itself as an act to make provision for enabling relief from payment of certain rent debts under business tenancies adversely affected by coronavirus to be available through arbitration. It's designed to resolve disputes in relation to rent for businesses which were told to close during the pandemic, and staggeringly there were £7 to £8 billion worth of rent arrears accrued during the course of the pandemic, and the Act is designed to bind parties into the result of the arbitration. So once the arbitrator makes their award, both parties are bound by it, and both parties can't stop the process at any point once it starts. So it is, it is quite a sort of, it's designed to be a final piece of legislation. Crucially, I think it will only apply to arrears that have accrued where parties have not already reached an agreement. So it's not going to be retrospectively setting aside rent deferments or rent waivers or anything like that. And it replaced the pre-existing restrictions which existed and introduced a new moratorium that will prevent landlords from exercising their usual remedies only insofar as they relate to ring-fenced rent arrears. So where there are non-ring-fenced rent arrears, landlords will be able to use the sort of full panoply of enforcement methods, and I'll come on to that a little bit later. Crucially, this Act is not going to be around forever, and the moratorium it introduces expires on the 24th of September 2022. So unless the Act is extended, which I very much doubt it will be, on the 25th of September of this year, there will no longer be any restrictions on landlords' abilities to enforce in respect of any arrears. So if you want to use this moratorium, you need to move quickly. The Act is also accompanied by a new code of practice for commercial property relationships, which replaces the old code, which I think was introduced in June of 2022. And the code, while the code supplements the Act, it is voluntary and has a wider scope. So it makes it clear, and as they've always said, sort of ad nauseum, that where possible, parties should seek to come to an agreement before the arbitration process is used. But I mean, my own personal view is that if you haven't come to an agreement in the last 2 years, you're probably not going to suddenly do it now, but maybe I'll be proved wrong on that. Just finally, what types of tenancies are covered? It applies to business tenancies as defined in the Landlord and Tenant Act 1954. So it's probably easier to explain what kinds of tenancies it doesn't apply to. So it won't apply to licenses, tenancies at will, agricultural holdings, tenancies of less than 6 months, farm business tenancies, and mining leases. I think that's probably it. So what clearly the definition of rent is important, and once you've decided whether the sums qualify as rent, then you need to consider whether the Act applies to them, and I think there might be some argument over this. So the Act applies to rent, service charge, insurance costs, landlord's management costs, VAT on all of those sums, interest on those sums, and any amount drawn down by the landlord from a rent deposit to meet the rent debt. So basically all sums due under the lease. It does not apply to rents which have already been paid, except rent deposit sums. So once the money has been paid, it's gone basically. And in order for the Act to apply, the rent debt must be protected. Such debts will qualify for protection if the tenancy was adversely affected by coronavirus. And what that means is that the whole or the part of the business was subject to a government closure requirement. So if you have a business which wasn't forced to shut but still suffered from a general kind of loss of trading income, those arrears will not be protected. So you're really thinking about, you know, pubs, restaurants, hospitality, non-essential retail, all of those sorts of businesses. And the sum due must be attributed to a period of occupation by the tenant within the protected period. So in England, we're talking about a maximum period of the 21st of March 2020, which is when the restrictions were introduced and businesses were forced to close, to the 18th of July 2021, which was sometimes referred to as Freedom Day. And that was the last day on which certain businesses were forced to close. The periods will be slightly different for Wales as well, so do bear that in mind. And it's worth noting that the protected period will of course differ for different types of businesses. So for example, for garden centres, it will only apply from the 21st of March 2020 to the 13th of May 2020, whereas for nightclubs, that will be the entire period, so 21st of March 2020 to the 18th of July 2021. And when a tenant makes a payment which is not applied to a specific period, the landlord must apply those sums to the unprotected debts first, i.e. those debts, those arrears which accrued before the 21st of March 2020 or after the end of the protected period for that business. Appreciate that might be quite confusing. So if we go to the next slide, I have included a quite helpful graph that the government produced. I hope you can all read it okay, but it just shows the different protection periods for different types of businesses in both England and in Wales. So that's actually an annex to the code of practice. So if you do want to take a look at that, it's readily available online. If we go to the next slide, just like to talk a bit about how the process is intended to work. So if no agreement can be reached, either party, so either landlord or tenant, can refer the claim to arbitration. So the first step will be to notify the other party of your intention to apply. And a landlord or a tenant can do this, but not a guarantor. And then you have to wait for 14 days for a response. If a reply is received, the party that initiated the process has 14 days to consider that response and reply to it, or once 28 days from the initial letter of notification had passed, the application to the arbitrator can be made. And this is actually really, really important because the moratorium ends on the 24th, or the last day of the moratorium is the 24th of September 2022, But actually, if you want to make an application, you need to start the process at least 28 days before then. So if anyone is considering making an application or a reference to the arbitrator, I would strongly advise doing so in the next few weeks. And once the application to the arbitrator is made, you have to include a formal proposal supported by evidence for resolving the matter of relief from payment of the protected debt. And the other party then has 14 days to submit a counter proposal. Once that counter proposal is made, the arbitrator will consider the proposals, consider the relief, and consider crucially whether the tenant's business is viable or whether it would become viable if provided relief from payment. The aim is to protect the viability of the tenant's business balanced against the solvency of the landlord. And I'll talk a little bit about that process later because it's quite important. And then the final step is the arbitrator will make a determination on the papers unless either party requests an oral hearing, and then that award will become enforceable. So if we go to the next slide, I'd just like to talk a little bit more about this viability assessment. Thank you. So I think the first thing to say, which is really important, is if the arbitrator considers the tenant's business to be a hopeless case, already sort of circling the drain, and no matter what award is made, they will still likely have to go through some sort of restructuring or insolvency, he or she will not make an award. Similarly, if the tenant's business is thriving and they're able to make that and then they're able to make the payments of the sums due easily, then no award will be made. So the crucial balance really is this tenant's business viable now, and would it become viable if an award for relief was made? And in considering that question, the arbitrator will review the assets and liabilities of the tenant, including other tenancies to which they're a party, and they'll do the same process for the landlord, including other tenancies to which the landlord is a party, in order to consider the landlord's solvency as well as the tenant's viability. They'll also consider previous rental payments made under the business tenancy, the impact of coronavirus on that business, and they would disregard the possibility of tenants borrowing money or restructuring their business in order to make payments. So basically, it's a very, very wide brief. And if we could go to the next slide, there are a few more important things to consider. So the arbitrator will be chosen from an approved list of individuals. There are a number of bodies who are able to carry out arbitration. RICS, I think, is probably the biggest one. Fulton Chambers as well have their own arbitration body. So the arbitrator will be assigned from the organisation that you apply to, but you cannot choose a specific arbitrator. No application for arbitration can be made where the tenant is subject to a CVA or an individual voluntary arrangement, and no application for a CVA or individual voluntary arrangement can be made until 12 months from the date of the arbitrator's award, or if sooner, the date upon which the arbitrator dismisses the reference. In terms of fees and costs, the arbitrator's fees are limited by the Secretary of State, although they are, I think, will still be fairly significant. And the party that refers the case to the arbitrator must generally pay their fees unless there's an oral hearing in which liability for the fees will be joint and several between the two parties, and the arbitrator will make an award in relation to their fees, as well as considering the award to make in relation to the protected arrears. In terms of costs, each party must pay their own costs, I think, unless there's a sort of egregious abuse of process or sort of malice involved, which I think would be very unlikely. And the award will be enforceable in the same manner as a judgment or order of the court. So if we go to the next slide, this is the interaction between the arbitration process, the moratorium, and other enforcement measures. Basically, in respect of protected arrears, a landlord, there's now a complete moratorium against all enforcement options. So whether that's a debt claim, commercial rent arrears recovery, forfeiture, winding up proceedings, bankruptcy orders against individuals, or even drawing down on a deposit to recover ring-fence sums, you're stuck until the 25th of September. For unprotected arrears, landlords are able to, as I said earlier, use the full range of enforcement options. I think we're already seeing quite a lot of forfeitures, and I expect that to continue. Debt claims issued before the 10th of November 2021 are not affected by the legislation, but if they were issued after that date, they're automatically stayed. If a landlord draws down on the tenant's rent deposit to recover ring-fenced arrears before the legislation passed, the tenant won't have to make up the shortfall in the deposit until the end of the moratorium period. And bankruptcy order made against an individual tenant or guarantor in relation to ring-fenced arrears after the 10th of November 2021 is to be considered as void. And then finally, if we go to the next slide, I'll just very briefly run through some criticisms which have been discussed quite a lot and are sort of obvious, I think. This act was rushed. I think actually it's actually fairly impressive that they got it through so quickly, but there are problems, and you won't know until you won't know how it works really until you give it a go. So I think the first is that there's likely to be a wave of referrals, I would say, in the next kind of 6 to 8 weeks. And I'm not sure whether there's going to be enough arbitrators or whether they're going to be able to, consider each reference in the sort of detail that they'd like. The timescales are extremely tight. 14 days is not a long time to review a proposal and provide a detailed counter proposal supported by evidence. There's no obligation on either party to make full disclosure of all the relevant evidence. So query how you can possibly make an informed decision on a proposal or counter proposal without sort of all the evidence in front of you. And similarly, many tenants might be subject to a number of similar referrals to different landlords and different arbitrators, and that could lead to lots of different awards based on essentially the same facts. So it is quite random, and as I say, you don't know which arbitrator you're going to get. And oral hearings, if one is requested, will be a concern where you're talking about commercially potentially very sensitive material about tenant viability and landlord solvency. So that is it. I apologize, that was a rather whistle-stop tour, but there's a lot to get through in relation to the act, and if you do have any questions, please put them in chat box, and I'll do my my very best to answer them at the end. So yes, thank you very, very much, and I will hand over now to Phil.
Thanks very much, Jack. That was really good. Hello, everybody. I'm Phil. I'm an associate in the Bristol team of the property litigation team here at BWB. So Jack's taking you through something pretty heavy. I'd like to take you through something possibly a little bit lighter. Hopefully it will be old hat for a lot of you, but there are a few cases sprinkled in, which hopefully will be something new to think about. I'm going to be talking about rent reviews and service charges. Those are really important things right now when finances are tight. If you're a landlord, you want to make sure that you're getting the best rent that you possibly can. If you're a tenant, you don't want to be overpaying for a property that you're in. In terms of service charges, obviously, if you're a tenant, you want to make sure that you're getting the most for your money. And if you're a landlord, you want to make sure that you are recovering as much as you possibly can for the services that you're providing, or able to not provide the services that you're not getting paid for. So for rent review, we'll talk about three things. I apologise, I'm not a poet, but there's three things to consider before you trigger your rent review. There will be further poetry as we go through. I apologise in advance, it's terrible. So the first thing, really basic, and it almost goes without saying, but I'm going to say it anyways. Before you trigger rent review, you have to make sure you know what the basis of your rent review is. I think most rent reviews are upwards only, and a fair number are based on a market rent. And so there is a sort of a perception generally that if the market's going up, you trigger rent review and you're fine. But they are creatures of contract. They are subject to negotiation at the start, and for various reasons, sometimes people agree different things. So you could have an upwards only rent review, or you could have an upwards downwards rent review, which could go down. Similarly, you could have a rent review which is a market rent, subject to some assumptions and disregards when being applied, or you could have a rent review which is tracked and linked to an index. And we all know at the moment that indexes are going crazy whilst the market is stuttering along a bit. So you could get a very big difference in your rent review depending on whether it's index linked or market rent. And you could see a rent going down. So if you're a landlord, you might not want to trigger a rent review in that situation. Similarly, if you're a tenant and the market's going down, don't trigger rent review if it's upwards only, please. Bear that in mind. So just set that down as number 1 point. Know how your rent review works before you trigger it. Second thing is a point about timing. And it's this slide, and there'll be another slide just after it. It's really important that you get the timing right when you trigger a rent review, because it can make a huge difference. There's 4 things on this screen that I'd like to quickly run through. The first is the valuation date. Ordinarily, a rent review will be calculated as at a specific date. So sometimes you can discuss it in advance, but it take effect from a certain date in the future. Or if you haven't agreed it by that date, it's retrospective back to that date. But not always. Sometimes a rent review will have a variable review date, which may only take effect, for example, on the date that you trigger the review. And if that's the case, you may have a different result. So be wary of the time at which you trigger the review. The second point is one of evidence. As I say, you can often trigger a rent review early, but the new rent won't take effect until a certain date. If you do that, you might not have the evidence that you need to substantiate the rent that you hope for at that new date in the future. Similarly, if you leave it too late, the evidence may have been obscured in the midst of time, or people's shredders, or new evidence may have come up which you didn't foresee coming up, which may mean that your rent review outcome is slightly different. You should always take professional advice from a qualified surveyor when doing rent reviews, and they will be able to advise you on appropriate timing as well, and the evidence that they've got. But it's something to think about before issuing a rent review notice without thinking. If you're a tenant, there's quite an important point about back rent interest as well. Ordinarily, a rent review clause will say that once the rent has been determined, the total back rent is then payable within 14 days. But there is also interest payable, usually from the date that the rent would have fallen due had it been at the higher rate, all the way through to the date that it was concluded. And if that's the case, it's really important that you get on and get the rent review done quickly, rather than allowing it to run, particularly if the interest rate is quite high. Now, we don't know what interest rates are going to do in the future, but people are worried that they might rise quite substantially. And if that's the case, you want to get your rent review in early so that there's not as much interest payable on the back rent when it's determined. And obviously, you can't pay the rent early. You might want to, but you can't. So you need to get the rent review done to avoid that. Similarly, there's a point about limitation here, which unless the rent review is subject to a time of the essence clause, which I'll come on to, there is no limitation period for a rent review. So a landlord could, in theory, if they want, or tenant, I suppose, could leave a rent review for a very long time and then exercise the rent review many years down the line. And the tenant will then have to retrospectively pay the difference over that period. And that can be really make it difficult for people to plan, even if it's been more than 6 years, which normally people think 6 years have come and gone, that's the limitation period. I don't need to worry. It can still apply. And we know that from the ideal view case that's on the screen. So it's quite important, if time is not of the essence, to make sure that you trigger the rent review pretty promptly. So this is time of the essence. Ordinarily, a rent review clause will not, time will not be of the essence. And what that means is that if a party doesn't trigger the rent review by a certain date, doesn't matter, they can trigger at any point they want. It's absolutely fine. And that's the general standard position that you will find. Some leases might have an express requirement or an express clause in there that time is of the essence. And it will be pretty obvious. It will say, for the purposes of this rent review, time is of the essence. And if the review isn't triggered by that particular point in time, the right to call for that review will be lost. So if it is a time of the essence clause and you're planning on using the rent review, use it quickly so that you don't lose the right. Now, there are some situations where it's an implied term that time is of the essence as well. So if it's not written into the lease explicitly, there may nonetheless be an argument that time is of the essence. Now, that's normally in cases where the tenant has a break option. The reasoning being that if a tenant has an option to break the lease, they should know what the rent will be before they have to exercise the break. Now, the cases are mixed and courts are very, very reluctant to imply terms into leases in these circumstances, but it does sometimes happen. So even if time is not of the essence explicitly in the lease, just bear in mind that you might need nonetheless to act reasonably quickly. Now, the other thing that can happen, even if there's no express clause and no implied time of the essence clause, is either party can serve notice on the other to make time of the essence. Now, I'm sure you're all aware from residential conveyancing, ordinarily you get to, through exchange, you get to the point of completion and somebody doesn't complete, and you serve a notice to make time of the essence, to force them to complete or to lose the right. The same applies to rent reviews. So that might be expressed, it's very unlikely, but there might be an express clause in the lease allowing one party to make time of the essence by serving notice on the other, or more usually it might be implied. So if the lease is completely silent, then either party can fairly regularly serve a notice on the other after a reasonable period of time, after the rent review could have been concluded, to say, time will now be of the essence. You have a reasonable period of time within which to exercise the rent review. Now, because that's an implication, it's subject to all the usual rules of interpretation that we're all familiar with. And so we see from the Proxima case a few years ago that it doesn't always apply. It's not always available. So if there's anything in the lease that contradicts that implication, then the court will not draw that implication. And in that case, it said, in the lease, the landlord can exercise the rent review at any time after a certain date. And what the court found was the words "at any time" clearly meant that the parties wanted it to be exercisable whenever, and so the tenant in that case could not make time of the essence. They couldn't force the landlord to do it. So it's a bit of a minefield. Generally, you'll be okay delaying it as long as you like if you're the landlord, but just be aware that there may be reasons why you need to trigger it more quickly. And on this slide, there's just a few other things that you might want to consider if a rent review is unavailable for some reason or is inappropriate. Consider whether you can do a 54 Act lease renewal instead of triggering a rent review. As I'm sure you're aware, the rent calculations under the 54 Act are different, or quite probably different to any lease. There's a set of statutory assumptions and disregards that may lead you to a different result, and it can go down. So if you're facing an upwards only rent review, but you are in a position where you could trigger a new lease, call for a new rent, possibly call for an interim rent as well, consider using the 54 Act instead. It might be more advantageous. You may simply be able to negotiate. We're in a slightly crazy market at the moment. You may be able to negotiate a better rent or a lower rent, depending on who you are, by taking a longer term, giving up a break, whatever it might be. So that's always an option to run alongside your rent review process. And if you really can't afford it because your rent's too high, consider subletting, sharing, trying to assign the lease if you can, some other way of generating a little bit more money that might help you to pay the rent in these new and uncertain and difficult times. That's all I've got to say for rent reviews, and we'll move on to service charges. Here we go. I warned you, there's more poetry. I'm not Northern, so I can't pull this off, but I couldn't find anything else to rhyme. So 5 things to understand before you demand, or 5 things to doubt before you pay out if you're a tenant. Again, I'm going to start with the really basic stuff, points 1 and 2 here. Just check whether or not the service has actually been provided before you pay a service charge or you demand for a specific service, and check that the costs have actually been incurred. That applies whether you're a tenant or a landlord. If you're a tenant, you will obviously want to make sure that you've received the services that you're being asked to pay for. If you're the landlord, you will want to avoid dealing with unexpected challenges or questions about the services that haven't been provided and why they're being paid for. So obviously check this. One of the important points to really hammer home from this slide is, unless there is a right in the lease for the landlord to claim money on account or a service charge or a reserve fund or a sinking fund or something like that as part of a service charge, the landlord can't do it. There is a tendency to raise demands for sums that haven't yet fallen due, i.e. the landlord is not yet obliged to pay them, and that should not be happening. So if something's due in the future and you're a tenant and you know that, just check whether or not it should actually be something that you're paying for, because the costs may not have been incurred yet and the service may not have been provided to you. You may be fine not having to pay it. Perhaps more pertinently is there a requirement to pay for the particular service that you've received if you're a tenant? Quite often we see that landlords, sometimes for very good reasons, will roll out the same services across the whole estate without paying a whole lot of regard to the specific services that they're required to provide or can provide and recover costs for under each individual lease. So it is always worth checking whether the services that are being provided are actually the same services that the lease allows the landlord to recover the costs for. And there are lots of grey areas that come up here, which is why I wanted to raise it. And there's an interesting recent case on it as well. So normally we're aware that the lease will have in it a list of services, usually in a schedule stuck out saying that the landlord will provide or may provide all of these services and the tenant will pay for them. But that list is often sometimes subject to some vagaries, and some of those are listed on the screen for you now. One of the big ones is, what's the difference between a repair, a defect and an improvement to a property? So a lease may say that the landlord shall keep the property in repair, shall obviate defects, and can improve the building if it wants. that will be unusual. Normally it just says repair. And in that case, sometimes works may appear to be correction of defects or improvements to a building rather than, strictly speaking, a repair. And that can lead to some uncertainty, it can lead to disputes, and it's something that landlords and tenants need to pay attention to when demanding or paying service charges. And that came up in the Great Arthur House case. It's a residential case, but it's an interesting reminder that particular building contained defects, and the court was asked to explain essentially the difference between what will be fixing a defect and a repair. And what the court said is basically it's a matter of degree. Well, that's a bit of a weasel, that doesn't help anybody. But what they specifically did say was that in order to be a repair, there has to be a disrepair. And it's perfectly possible to have a building that is defective in some way, but is in good repair. And in that situation, fixing the defect is not going to count as a repair. But if a defect has, for example, caused some other damage, and in fixing that damage, necessarily you have to fix the defect at the same time, that's probably okay. That will count as a repair. As I say, it's a matter of fact and degree, and it is worth taking professional advice, or particularly from a surveyor at that point, to work out precisely what it is that you are doing before you include it in a service charge. As to improvements, those normally aren't included in a service charge, but landlords will sometimes end up effecting improvements as part of a repair. And again, it's a matter of fact and degree. A tenant cannot dictate to a landlord how it does a repair work, but the landlord does have to have regard to the tenant's interest in how it carries out the repairs. And the leading case not on there is the Fleur Daniels case, in which a landlord repaired a roof by replacing it, and the tenant had a very short time, let's say a year for the sake of arguing, left on the lease, and the tenant said, well, hang on a minute, you're getting 30 years of good roof, which you want me to pay for, and I'm only going to use it for 1 year. That can't be fair. And in that case, the total that was recoverable was reduced accordingly. So again, just bear in mind what it is that's being done when dealing with the service charges. Management charges are another thing that quite often has quite a lot of grey areas in it. Obviously, as landlords, you will incur, or if you're a landlord, you will incur management costs in providing the services. If the lease specifically allows for management charges to be recovered, great. If it doesn't, make sure that you roll them into the cost of the services themselves. If it's emptying the bins and you need to manage that in some way, make sure you include that in the emptying the bins part of the service charge. Don't do just an extra line at the bottom that says management charge 10%, because that won't wash, unless the lease allows you to, and the court won't allow it. So pay attention to that. If you're a tenant, again, just have a look to see if there is that extra line that's stuck in, and see if it's something that should be included in the service charge. And again, insurance charges, I mean, this is usually a rent rather than insurance rent rather than a service charge, but it's the same point. Just make sure that the insurance that is being demanded, or the costs of which is being demanded, does actually marry up with the insurance that's required to be provided by the landlord under the lease. Employers' liability insurance and things like that sometimes get rolled into the policy, or it might be a bulk policy across lots of different properties. You want to make sure that it's appropriate, and you can usually ask your landlord for a copy of that to be able to make that decision. As well as the fixed list of services, there's also often sweeper clauses that we'll find in the schedule. It will say plus any other services that the landlord considers should be provided, and that's usually quite a useful get out. The RICS code does say that landlords should not use that to provide services that they have otherwise forgotten to include in the lease. It should be for changing circumstances or a few odds and bits and bobs here and there. It should not be for big things. Ordinarily, a landlord's there's going to be some sort of description in the lease about how the landlord can exercise that discretion. It'll normally be landlord's reasonable discretion. It's an objective standard. We all know what that means. In the interests of good estate management, again, it's an objective standard, but it won't always have that. Sometimes it will just say any other services the landlord, in its discretion, cares to provide. And in that case, if it's completely silent, the rationality test from the Braganza case from a few years ago will apply. Essentially, you have to, when working out what service to provide, you have to follow a proper process, take account of relevant considerations, discount irrelevant considerations, and come to a result which isn't so absurd that nobody else could come to it. Now, those of you that work in the public sector will be well aware that's basically the Wensbury unreasonableness test, to be well aware of it, but it's been imparted into private contracts as well by the Braganza case, where there's no other objective standard. Nearly there. This one, again, it's not a big point, but I raise it because there's a recent case on it. Make sure that you're allocating the service charge correctly. Normally, that's not a difficult thing to do. It should be fairly simple to do. At the moment, given that there are quite a number of empty units, just make sure whether there are any exclusions in the lease. For example, the tenant's not going to be best pleased at paying the full service charge if they're the only person in a shopping centre. Quite probably there will be exclusions for empty units or units occupied by the landlord. So that's something to bear in mind if you're a landlord in terms of demands. If you're a tenant, just double check it to make sure it's fine. The reason I've put this here is this recent case, the Criterion Buildings case. In that case, the landlord had to divide up the service charge in a fair and reasonable manner between all the different tenants in the building, and it would receive 100% back, however it divided it up. And the court said that that was a subjective test in that particular case. I'm not sure I follow the reasoning or agree. We normally think reasonableness is an objective standard, but the court said it's a subjective standard, and that was subject to the test of rationality that I've just mentioned. In any case, it has to be done in a proper way and not be so absurd that no one else could come up with it. What the court also said was, where the landlord does have to do this allocation, landlords can generally be trusted to come up with something sensible. It's not in the landlord's interests to favour, well, it could be, but generally won't be in interest to favour one tenant over any other. The landlord's getting 100% back, whatever they do, ordinarily, and therefore they can be trusted to come up with a sensible number. So don't sweat too hard when coming up with that fair and reasonable division. Here we go. This is the big one, the one we've all been waiting for. Is there a right of challenge? Ordinarily, or we'll quite often see in service charges, that a landlord or a landlord surveyor can certificate the service charge, and it will say that that is conclusive. And there's been a bit of a hoo-ha recently because of the Black's Outdoor retail case. Now, in that particular case, the first instance, the tenant argued that there was a difference between conclusiveness as to the amount per service and the services themselves that are actually chargeable under the lease. And we've seen from the previous slides that sometimes things that aren't really covered by the lease get included anyway. And they said, this particular conclusiveness clause, you have to have a difference, then you must have a difference. And the court agreed. The court said it's conclusive as to the value of each thing, but it's not conclusive as to the services themselves. That was appealed by the landlord, and the landlord won. The Court of Appeal disagreed. They said that this particular lease said it was conclusive as to the sums due. That covered everything, and therefore the tenant was out of luck. They said it would cause too much uncertainty if there was a difference between fixing the cost of a service and working out whether the service should have been included at all. And they said that, frankly, if the parties had agreed that, that's up to them. The court wasn't going to interfere in what turns out had been a bad bargain. That's difficult to really justify. I think there might be a lot of tenants that are very nervous that the sums that they're being asked to pay might be completely beyond challenge, except in the case of fraud. Nevertheless, that is how the law currently stands. It is on appeal to the Supreme Court, so that may change. I suspect it won't. I suspect the Supreme Court will agree with the Court of Appeal, and that it's just an unfortunate, unhappy outcome on this particular case, on this particular wording in this particular lease. But the point remains that currently it's the law. So if you're a landlord, get your certificates in, provided you're happy, of course, with the service charge you've provided, because it binds you as well. So make sure you've got everything in there. And if you're a tenant, there's not a lot that you can really do, unfortunately. The main thing that you might try and do as a tenant is withhold some of your rent or offset it. Generally, there will be requirements in the lease that you don't do that. And if you do try and withhold some of your rent, you are at risk of forfeiture or other action to recover those sums. So it's very much a landlord's playground at the moment, so far as service charge certificates go. If it isn't conclusive, there is no conclusive certificate, just check in the lease to see if there is any time limit on challenges. Again, you might lose the right to challenge if you leave it beyond a certain period of time. And if there is a particular mechanism for challenge, referral to an arbitrator, make sure you follow that particular policy or particular procedure properly. Otherwise, you will probably end up losing the right to challenge as well. That's all I have to say about service charges. Thank you for bearing with me. I think we've probably got some time for questions now. Over to Nicholas.
Great. Thank you very much, Phil. Thank you very much, Jack. I'm glad to say, Phil, that we didn't seem to lose too many attendees with the attempts at poetry, so that's gone down well, which is great. Okay, so we've had some questions. First of all, then, this is probably more of a question for Jack. As a local authority landlord, what is to stop us waiting for the moratorium period to end and then use traditional court proceedings, assuming the tenant doesn't themselves opt to seek arbitration themselves? So effectively, what's the point of the Commercial Rent Rights Act 2022? And I suppose a follow-up from me personally, are you seeing it used in practice?
We are seeing it. We are starting to see it get used in practice. I think there is a benefit to having waited slightly. Obviously, in terms of kind of cash flow and kind of feeling, letting other people be the guinea pig. There is a benefit to waiting slightly, but I think we have certainly seen some referrals starting to come in, some notification procedures beginning. So I expect there'll be much more of that. In terms of, if you're a local authority landlord, what's the point? I mean, you can of course wait. There's absolutely nothing stopping you from doing so, waiting till the moratorium expires and then issuing a statutory demand or using traditional debt proceedings. I suppose it's a commercial decision, really, and depends how sort of urgently you need the funds in. And also I think there is some benefit to having control of the arbitration process, because as I mentioned, the timescales are pretty tight, and sort of once the kind of arbitration train leaves the station, you can't sort of get off without an agreement or until the award is made, if you'll allow me to sort of overextend the metaphor. So, actually being in control of the timescales, being able to have kind of readied your submissions and then kind of trying to catch the other side out of it, there is some benefit to that, I think, just in terms of preparedness and the evidence that you're presenting to the arbitrator.
Okay, so essentially with the short timescales under the arbitration process, that's probably far preferable to goodness knows which local county court you're going to be in and what sort of backlog they've got and things like that. So speed is sort of one of the primary things.
Exactly, the act is designed to kind of whip through very quickly and produce a binding result, but 14 days to review what will probably be quite a detailed proposal supported by lots of financial evidence and those sorts of things, and then provide your own counter proposal supported by evidence. It's going to be very hard, I think.
Yeah. I was going to say the other thing is,
no, go on, Phil.
I was just going to say, if you think that the tenant is likely to use the process, get on and instigate it quickly. If you don't think they're going to use the process, you could just wait for the process to end or moratorium to end, and then start bringing it. But if you think they're going to do it, a well-advised tenant quite probably would wait until very late in the day before initiating the process. So then, as Jack says, it could go on for a very long time, but then you've lost 4 or 5 months that you could have gained, because you still can't take any action till it ends, basically.
And just following up in terms of, I think we sort of talked about evidence on financial viability just then. Follow-up question: will the arbitrator take COVID grants available to tenants into account when considering financial viability and solvency?
The answer is yes. I think they would have to have been in receipt of those grants. I suppose when you were presenting your submissions to the arbitrator, you could outline the grants which were available and which a tenant failed to obtain as kind of some evidence of I don't know, I guess sort of contributory negligence, I suppose. But if they were in receipt of any sort of funds during that period, then you presume they would appear on the balance sheets and the accounts and financial data for those years, and they would be factored into the kind of overall viability assessment.
Okay, in terms of, I'm quite interested in the practicalities of it. Very interesting that under this arbitration hearings are public. Is there, have we seen public ones? Have we seen decisions published? Are we starting to get a feel for how arbitrators are dealing with it, what they're taking into consideration and things like that?
I haven't seen anything, I have to say. I think the option of the oral hearing is not really likely to be kind of appealing to many of the parties. So I haven't really seen sort of anything. It seems to be kind of all going on slightly in the shadows at the moment, and obviously it will include sort of quite commercially sensitive information, and also as I mentioned, there's the same tenant or the same landlord could have very similar fact patterns for a number of different properties and leases, and get quite different results. So I think sort of guarding that information is likely to be in both parties' interests. So there hasn't been a huge amount of that sort of coming out. I don't know if Phil's had a different experience, but it's certainly been quite secretive so far.
Perhaps unsurprising, really. So the downside of that is no sort of guidance as to how other people are approaching it or anything like that. From a landlord perspective, when we're sort of advising landlords, what approaches are there to take, or what evidence can we put in or could be put in terms of sort of trying to counter the arguments of the tenant, or is it just basically for the tenant to kind of try and prove its case? Is there anything landlord?
Yeah, I mean, so the starting point is that the tenant has made a contractual promise to pay rent, service charge, all of the sums due under the lease. And if they're able to, they should be required to pay in full. So there's a kind of rebuttable presumption really that the tenant must pay everything. So that's the first. I mean, that's the first point. You start at 100% and you work backwards rather than starting at 0 and working upwards. So that's obviously in favour of landlords. If there is a genuine question over landlord solvency, if the arrears are absolutely massive and it's a small landlord and a big, larger tenant, and there's questions about solvency, if they don't, get a large award, then you would obviously need to adduce evidence of that, potential insolvency, I suppose, and then it will sort of be balanced against the viability of the tenant's business, and then I suppose you would also probably try to kind of seek to adduce evidence of how you tried to assist the tenant during COVID, include details of any grants that the tenant was able to obtain, all of those sorts of things. So I think it's just about kind of chucking the kitchen sink at it as far as possible, really, and also potentially responding to any points that any specific points that the tenant makes, or highlighting any kind of inconsistencies in their arguments, based on the kind of information that they're able to provide, and the documents they disclose. But as I said before, obviously you only need to disclose evidence which is sort of favourable to you, really. So both parties are slightly going to be fighting the other with one hand tied behind their back, because you're unlikely to just get this. You're unlikely to be given disclosure as sort of a full picture, really. So it is. I think that's probably the most significant criticism from my point of view.
Yeah, and the other thing you can do, and you have to be careful about how you do it, of course, is if you're a landlord, in order to avail itself of this relief, the tenant has to basically say, I'm nearly on the rocks here, I really need your help, and I can't afford to pay this rent. That's a pretty big thing for a tenant to have to say, particularly if they are the sort of tenant that may, for example, have investors that pay quite a lot of attention to how they're doing. They don't want to have to say that. And so if you're a landlord, the more you can hammer home to them, are you really saying you're doing that badly, might cause a tenant to either think again or put in a pretty mealy set of evidence, because a tenant isn't going to want to put in loads of evidence to say just how badly they're doing, because that's really commercially bad for them to do. So you've also got that psychological advantage if you're a landlord.
I suppose, yeah, you can almost bring in sort of directors' duties not to continue trading insolvency. So the tenant, as you say, the tenant's got a difficult, almost balancing act or tightrope to kind of tread. Okay, great. I'm conscious that we're a couple of minutes over past 11 now, so I will stop grilling the two of you and instead say thank you very much for your very interesting presentations. As I said previously, we are going to do a roundtable event on the 28th of June. We can go through these topics in more detail, particularly the coronavirus, Commercial Rent Coronavirus Act, or anything else that you might want to talk about in terms of commercial property. If you're interested, then please fill out the poll and we can follow up with an invite for that. But other than that, it's just to do, again, say thank you to Phil and Jack and all of our attendees for your time today. Thank you very much.
Thank you.
Thank you.